We did. So I want to start with good morning to everybody, or good afternoon now. Welcome to the Real Estate Rundown February 2022. We're going to talk about closing issues and escrow disputes. This is a topic that is changing pretty regularly as things come up. So I'm going to try to hit on some of the big stuff, and then we'll go back and we'll look at some things, hopefully if we have time, that you've been seeing as well. As always, my disclaimer, this is general information about the topic. It's not legal, financial, or accounting advice. And you really do, especially in an escrow dispute, you really do want to talk to an attorney before you make any recommendations. You don't want to be the one making recommendations to your clients on this. You want to be if anything, you want to be forwarding the attorney's advice. But if you can get it in writing, that's even better. And then you're passing it on the email. You're not passing on a specific bit of advice. So a bit more about me. I handle a lot of our title practice here. I'm admitted obviously in Florida, as well as New York and New Jersey, as well as three federal courts. I handle probate, I handle business law, real estate law, and title. I'm the primary contact for the real estate law and title section here, as well as for the probate section. And our firm is a law firm in New York, New Jersey, Florida, and Washington. We do estate planning. We do obviously real estate law, Medicaid planning, probate and business, and we act as title insurance agents, escrow agents, closing agents. We handle all of that. We work with real estate agents all over, and we also handle education, as you can see, legal support, and we have meeting space for conference room, for conferences, for teams, or if agents need to use the room to meet with excuse me one second, need to use the room to meet with a client, we are available for that. So let's talk about what our presentation is going to look like today. We're going to look at issues, obviously, first that arise at or close to closing. We'll talk about financing issues that come up near the closing table and at the closing table. And then we'll play through a couple scenarios and who gets the escrow. And then I'm going to walk you a little bit through what a dispute looks like. This changes somewhat, and we'll talk a bit about it, but we'll walk through part of what it looks like. So let's first look at the issues arising at the closing table. One of the ones I've been seeing a little bit more is buyer or seller's remorse. We'll talk more about what that means. Inability to make a final payment. That's starting to be a bit of a problem here. The seller not ready to move out, and then the party to closing being unavailable, which is surprisingly something that we've had happen more often than not. So we start first, obviously, with buyers or sellers' remorse. Sellers may get remorse. They may decide they want to try and sell the house to somebody else for more money. As the market keeps going up, they say, you know, we settled too quickly. Let's see if we can't get more money. Let's cancel this deal and resell it. Or buyers may decide they've acted too quickly, too hastily, and they don't want the house anymore. This is especially prevalent with a cash deal and not as much with a mortgage. In these two cases, assuming there's no other issue, my advice to both sides is the same. You have to go forward with it. A seller thinking they can resell for more money is really asking for trouble here. And I'll tell you, and we'll get into the dispute process, but as part of the dispute process, if I represent the buyer, I'm going to tell them you can't resell the property. We're not canceling our contract. What that does is, as a title company, it prevents us from issuing a title policy because there's a possible blemish on title that we can't clear. So that's something to keep in mind. Like I said, it is something that we have seen where sellers have said, I don't want to sell yet. These two, I will tell you though, are two of the ones that are going to lead to the most litigation. Inability to make a final payment. This is one that I've seen very little of, luckily, so far. On cash deals, sellers agents have been pretty good about getting proof of funds. And the banks are pretty good about checking for proof of final payment, of availability of final payment. If the buyer's to cancel, though, they don't get the escrow back. If they can't make that final payment, they're not getting the escrow back. Can the seller sue on this? Yes. Just like in the first one, the sellers or the buyers can take this to litigation. But I don't recommend it here because if they don't have the money now, are they gonna have the money after a lawsuit? Probably not. So if the house can be sold, can be relisted, I would probably take the money and relist it. That's going to be kind of a bit more of a judgment call. That's going to be a bit more of a question about how much you're willing to go after them. But that is something to keep in mind here. Another issue that we've seen a few times now is the seller's not ready to move out. We've done closings where the sellers aren't turning over the keys right away, or they're coming to the closing and they're saying, and after the buyer signs, we're going to get the rest of our stuff out of the house. And the buyers are obviously supposed to do the final walkthrough at some point. So that's been creating some issues. Delays in closing on a new purchase, issues in securing movers, even wanting the kids to finish the year at the school. They've known about this, they've just not said anything. This is going to be a problem. This is continuing to be a problem, especially with inventory being low. If the deal dies because of this, the seller does not get to keep the escrow. And again, this is where litigation might come in. Sellers will ask for post-occupancy agreements. I want to talk a bit about them. Under the new FAR bar contracts, they don't need to be leases, but they are. They don't need to be a formal lease, but they still are. Post-occupancy needs to cover at least the following terms: rent, insurance, who's holding insurance. If the seller is not moving out, they need to keep insuring the property. A security deposit and a date certain of termination. I'm going to talk about that. Rent should at least cover the mortgage interest. Rent should at least cover what it's going to, the carrying costs of the house that the buyer is taking on from day one. And if I'm the buyer's agent, I'd want it to cover, quite frankly, all of their mortgage payments, if it's going to be more than just a couple of days. If we're talking 2 or 3 days, it's the daily, it might just be the daily interest. If it's a month, then it's a full mortgage payment at the very least. Plus you need to keep insurance on the property. Plus you need to give me a security deposit, which you know, the title company might be able to keep in escrow. That's going to be a discussion for them. Red flag. Most mortgages, though, require occupancy within 60 days, especially if this is a first mortgage or a prime, not a first mortgage, but a first-time home buyer, and they're buying a primary residence. 60 days, okay? So don't let a buyer agree to a post-doc that is longer than 60 days without talking to your lender. Your lender will tell you not to do it, that they can't allow it. 60 days is not how long you can make this post-occupancy agreement, though. If they haven't occupied the property by day 61, they're in breach of the mortgage. It's not that they're going to be looking at, oh, it should then have been a second home or investment home, and we're going to give you a new interest rate. No, the bank will call the entire loan due. Okay. This also doesn't change whether the post-occupancy agreement was for 35 days or 65 days. If the seller is in breach of the post-occupancy agreement and hasn't left, same issue. This can be a reason why people might not sue to evict, because they're worried about their lender finding out, but this is a real possibility. It's a real issue. So what's our best practices? Lenders say don't make the post-occupancy agreements for longer than 45 days. I say 30. 30 days lets you get them out if you have to with a summary eviction proceeding, which takes about 21 days. If you have to do a 45-day post-occupancy, I would want some kind of damages clause in there that says that if this loan gets called due, you're going to pay it. Excuse me, that you're responsible for any costs that I incur, including paying for the full mortgage if it gets called due. Just something to keep in mind, though, with post-occupancy agreements, especially as, like I said, this is something we've seen a little bit more lately. Another issue that arises at the closing table: planning trips around closing dates or medical emergencies, a party to closing being unavailable. We'll talk about this at the end, but in June, we're going to be talking about trusts, powers of attorney, and ladybird deeds. That's something that comes up here. This can really make a closing more difficult. We've had this issue come up a couple of times. We've been able to work on it for the planning of trips. Medical emergencies are a little harder. It's worth having a conversation with your clients. Do you have a power of attorney just in case? In case something happens, do you have a power of attorney? Somebody who can make the decisions for you. But planning trips around closing dates, again, definitely need a power of attorney. But the other thing that you need is to make sure that you're watching out for this. Make sure they know roughly when this deal is going to close. Make sure they're not planning a trip. Ask that question. Make sure the title company knows what's going on. This has caused delays and extended costs a few times. The planning of trips around closing dates, just so you're aware, and that's something you need to keep in mind as well. So some financing issues that come up at the closing table or near the closing table. Revocation of clear to close and inability to do final verification of employment for missing appraisals and surveys. So the first one is the revocation of clear to close. We've had this happen a few times with a couple of lenders that are calling up at the last minute and saying there's an issue and the deal was clear to close, but it hit final underwriting at the last minute and now it's not. There's a new condition that needs to be cleared and we're not releasing funding. That's come up a few times with a couple of lenders, mainly out of UWM, who I will tell you is normally pretty good, but they are they have their departments, and if something gets caught up in final underwriting, there can be an issue there. So that's something to keep in mind there. Working with the lender. Again, I have said that buyers and sellers agents should both be talking to the lender, should both know the lender, and that's the communication that should be coming up. Another big issue that we've seen is an inability to do final verification of employment. Again, a lot of lenders are making this call literally the day of closing. So if this closing is happening on the 16th at 2 p.m., they're calling on the 16th at 9 a.m. That's great, except what if somebody's out? That's wonderful as long as somebody's not away. HR departments at small companies are usually a little bit better, but if you've got somebody who works for Disney or Siemens and they just don't get to you, that can delay the closing. Okay. Have your buyers talking to the HR department to let them know, because if this closing gets delayed because of verification of employment issue, your buyer could be on the hook to lose their deposit. Okay. If there's an issue and the deal dies because they can't close because of final verification of employment, they could lose the deposit there. You also want to make sure though that lenders know when a company is closed. We had a deal over the summer that the lender couldn't get in touch with anybody from, it was closing on a Friday and they couldn't get in touch with anybody from HR. Turns out the buyer is a teacher and the school district closed on Fridays during the summer. Nobody was in the HR department. Some companies take off for Good Friday, some don't. Some take off for President's Day, some don't. Make sure your lender knows when your HR department, when your buyer's HR department is going to be closed. That's got to be part of the conversation here. In either of these, though, the buyer is the one who's at risk of losing the security, losing the escrow. In either of these, the buyer is the one that's at risk. If there's a financing issue, the buyer could lose their escrow if they can't close. I've also seen sellers saying, we'll extend the closing date, but it's going to cost you an extra $1,000, an extra $2,000. The sellers are well within their rights. If you're closing on the closing date, you're well within your rights to say we're extending, but it's going to cost you, or we're not extending. It depends, on the relationship there. Missing appraisals or surveys. Look, appraisals are delayed. I'm not telling you anything you don't already know. With the appraisal being part of the financing period, that's becoming more of a problem. If you were in my FAR contracts class, you know that my advice was to make the financing period 45 days. Make sure you're hitting that. Make sure that the appraisal delay is not causing you to blow your financing deadline, because you could cost your client their escrow deposit. Surveys. If you're buying or selling a property that's over an acre, be prepared for survey issues. We've done a few of these recently where the number of survey companies that are taking it is lower, and the costs are higher and the time is higher. Okay. If you're relying on the title company to get you a survey, we'll need to know earlier. Don't wait till the last minute to tell us you need a survey. I had one person tell us at the last minute, literally about a week before close, hey, we want a survey. And we told them, you're going to have to help us in ordering it. You're going to have to make some phone calls too, because we weren't going to get it done. On a good day, it's 8 to 10 business days to get a survey. With properties that are more complicated, you're looking at possibly 10 to 20. Keep that in mind. Is that going to delay financing? If your lender requires a new survey, then yes. A new or updated survey, then yes, that could delay financing. Could that delay the closing? Same thing, absolutely. If they're causing it to be an issue. So now let's talk about who's going to get the escrow. There are a couple of ways that I want to go over. Due diligence, title, other reasons, and financing denials. We're going to go back to a lot of the financing situations as we go through some of these denials. Cancellation by the buyer, though, over due diligence issues. Ooh. There's a specific due diligence period in the contract. It's usually 5 to 10 days, but it can be as long as 15 or 20 or even 30, I've seen. If the buyer cancels in that time, they get the escrow back. But let me stress this. Later discovered issues are not grounds for cancellation. If you come back later and discover that there's mold 20 days out after the due diligence period is expired, you're going to have problems unless you use the mold addendum. Okay. Florida bar dates are hard and fast. Later discovered issues are not grounds for cancellation unless they're in the contract. So you want to make sure you're doing your full due diligence if you want to be able to get your clients their escrow back. It's wood destroying insects, that's mold checks, that everything has to be done within that due diligence period, and that report has to be in by that due diligence period, and that cancellation has to be in by the end of that due diligence period. Having the report in and sitting on it and negotiating past the due diligence period doesn't extend it. Okay, if you don't send the cancellation by the end of the due diligence period, you forfeit your right to the escrow back. Let me say it again, it's important. If you do not send the cancellation by the end of the escrow period, you forfeit, by the end of the due diligence period, you forfeit the escrow. It is a mistake that I have seen brokers and agents make several times, and that is why I keep hitting on that point. Cancellation over title issues. The FAR bar contract does give the seller 30 days to clear title exceptions. That 30 days, though, starts from the date of the title commitment. It does not start from the date of closing. It is not a 30-day extension. Okay. If within 30 days they haven't, the buyer can cancel within 5 days and receive their escrow back. But if they don't cancel, again, what happens is as if it's waiving that right and they keep going. Okay. They can also give the seller another 120 days to clear title exceptions. Good title companies, I like to say we are a good title company, but good title companies will keep you in the loop about what's going on. Make sure that you know. If there is a title exception other than just, a mortgage, to help you clear it, keep in mind that 30-day date, though, starts at the title commitment. If you've got a 60 or 90-day closing for some reason, that 30 days may be well within the middle of the contract period. May not be an extension at all past the closing date. If they don't walk away, if the buyer doesn't walk away, they're accepting everything. Then again, they forfeit their right to the escrow back here. But the buyer gets the escrow back if there's a title issue and the seller can't clear it. The seller, though, does have that 30-day right to clear it first. Cancellation for other reasons, and I'll open this up to questions about, what some other reasons that you've had for cancellations. Look at the allowed time periods. If the buyer has an allowed time period, they get the deposit back. Within the financing period, for example, they get the deposit back. The seller can only keep, but the only time the seller can cancel the contract and keep the deposit is at the closing date. If the buyer's not ready to close, the seller can say, well, we're not moving forward, and cancel the contract. That's really it. That's about the only time. They can't do it if there's a title issue. They can't do it if there's a financing issue. It's only if the seller's not ready to, if the buyer's not ready to close. That's really it for the sellers. If the buyers try to cancel the contract outside of that period, outside of a cancellation period, then the sellers will get the escrow. But most of the time, if the sellers get the cancel the contract, the buyers will get the escrow back. I'm going to talk about financing denials real quick. Again, the financing period is a hard and fast period of time. If the denial doesn't come back within there, the buyer's going to lose their escrow. Talking to your lender, working with your lender, making sure your lender is on board with your time frame is huge here. Okay. And then remember, FAR bar contracts now include appraisals as part of the financing period. Now, there's an exception here I want to talk about, and I like to talk about this exception. It used to be if the lender denies the loan after the financing period because of an appraisal issue related to the property condition, and it kind of included valuation. That's gone now. Now, the buyer can cancel if they get denied after the loan denial period or the financing period, if there's a property condition issue that the seller won't fix. Okay, I think a VA loan comes back with the appraisal and they say you need to correct the bathtub. And the seller says, I'm not doing that. That may be a denial that's under that contract. But valuation for appraisals is not. All right. I'm going to go back to cancellation for other reasons. I kind of want to float that, see if people have questions about specific cancellations that they've dealt with before we go into what the process looks like when there is a dispute that gets past the brokers negotiating.
Do you see sellers canceling? Can you open that section again? The cancellation for other reasons?
I can.
Do you see that where the seller's canceling if the buyer's not ready to close at closing date? I mean, usually I could see it happening if it's like a 10-day closing or something fairly short, and so there hasn't been much time lost. But if it's it's a 30 to 45 day and they're very close to the closing date, and then buyer's not quite ready, I've so far, knock on wood, had sellers have been willing to agree to move it a few days to get things accomplished. But do you see that occurring much?
Not yet.
Okay.
Where I see that happening is usually in deals where we're on our second or third extension.
Right. Yep. That makes
sense. The first extension was for 7 days. Now we're on a second extension for 7 days, and we're about to be on a third extension for 7 days. And everybody's like, well, I don't know if we want to extend again.
Right.
And I've seen that happen there. I've also seen it happen where lenders are really not clear about what's going on. So we had a deal we had a deal that did not close on time. And in fact, we didn't order title on time. Again, this goes back to we communicate with buyers and sellers agents. The lender refused to order title until after the title deadline had passed. Wouldn't give us any information because they were waiting for the appraisal to come back. The seller's agent was for obvious reasons annoyed and went back to the buyer's agent trying to figure out what was going on. That was one that got a little dicey because they had to extend that a couple of times, once or twice, because the lender was acting in a strange way. It got resolved. It got taken care of. That was one where I thought it might, because the relationship between the agents had started to break down. On the first extension, that I thought got a little bit dicey. Other than that, no, I don't really see it at all for the first extension. I see it more, like I said, second and third extensions. I'll also tell you, I see it more for investor properties than I do primary residences. Because investor properties are more about the business.
For sure.
So,
I have one more, and then I don't know, Stephen was on mic there. I don't know if you had a question, but can you open up financing denials again? Sorry.
sure.
I need a trigger. Okay. So you mentioned the VA because I have one now. On a VA, if the appraisal comes back that there's an issue found where this has to be corrected before we can approve the VA loan, then it's possible the buyer and the seller doesn't want to do anything. It's possible, and the buyers aren't willing to do it themselves. It's possible for the buyer to still get their escrow back. But in the case of just a low appraisal, then not. Correct?
So let me go to that section. And I'm just going to read it out, right? So we're looking at section 6, B6 of the appraisal, of the financing language, right?
Yep. No, is
So
that the new one? 8.
I've got the new one. Yeah, 8B6.
Yep.
Buyer thereafter fails to close this contract, deposit shall be paid to seller unless failure to close is due to 1, seller's default or inability to satisfy the contingent contract, or 2, property related conditions of the loan approval, specifically excluding the valuation, that have not been met unless conditions are waived by the other provisions of the contract. Property related conditions generally includes things like, again, fixing a bathroom, making sure an outlet works. They can be smaller things, they can be larger things. But that's where that clause is going to come in, right? Property related conditions of the loan approval, because those are out of the buyer's hands. So if the loan approval is conditioned on fixing things that are highlighted in the appraisal, which happens with VA loans, it doesn't happen usually with regular loans, but it does happen with VA loans. I believe it happens sometimes with FHA loans. That can be grounds for the buyer to get their deposit back.
Thank you.
So, and I'll put that, let me just put that into the chat really quickly. Where we're looking is, section 8. B. I say 6. So that's where you're going to want to look for that. So, Stephen, you were unmuted for a minute. Do you have any questions?
No, I accidentally hit the unmute button there.
No problem. Just wanted to make sure I wasn't blowing past you.
I appreciate it.
So let's go back now to what does an escrow dispute look like? And again, now we look at section 16, which lays it out. Okay, there's a 10-day period, first of all. And that's meant that's a cool down period. That's meant for the parties to informally negotiate. This is where you want to make sure your broker is involved, by the way, and it may be your broker and their broker, maybe out of your realm here. But it's meant for the parties to cool down. It allows for, like I said, informal negotiations to just kind of talk and see if it can be resolved. If that fails, you do not go straight to court. There is a mandatory mediation, and both parties split this cost equally. Okay. Some brokers will tell you that mandatory mediation means that everybody's going to take a 50-50 split of escrow. First of all, if your client's not happy with mediation, they don't have to accept the result. Okay. Mediation, while the mediation is mandatory, mediators try to come to an equitable resolution. They do not force a split on everybody. They can't. That's not what mediators do. So it's not guaranteed to result in a 50-50 split of escrow because nobody has to agree to it. All right. If mediation fails, litigation. And that's where a judge rules on who's entitled to escrow. This can take months or years, though. Keep in mind, this is where, again, tempering expectations. This can take a while. The winning side's entitled, it says willing, it should say winning, is entitled to attorney's fees and costs, including attorney's fees. And depending on who's responsible for what, the buyers can create a cloud on title for the sellers. There's a way to skip a lot of this, and that's for injunctive relief. If you're a buyer and the seller says, we're not selling to you, we're canceling the contract, we have another offer, we're about to sell the property to somebody for more money, you can skip this process, go straight to court and get an injunction saying, no, we're supposed to buy the property. And we want the court to say, you can't sell it to somebody else. An injunction prevents a seller basically from selling the property to somebody else if you know they're about to do it. You know, injunction or restraining order, those avenues are available to you if the breach is imminent, right? If, like I said, a seller tells you, I'm not closing with you today, John Smith from down the street offered me $5,000 more and I'm going to take it. So sorry, you can have your escrow back, but there's nothing you can do. Attorney's fees, if the buyer wins them, will probably come off the price of the house. But if the seller wins them, expect them to just be added on to the amount that the buyer has to pay. Because of that, I don't recommend litigation for sellers all that often beyond an escrow dispute. If the buyer gets rejected, denied for a loan, and you want to sue, what's that going to look like? That's going to, if they already can't get the money to buy the house, a lawsuit is not going to help them to do that. So litigation, in my mind, is really better for buyers than it is for sellers for anything other than escrow. But there are circumstances here. If it's a cash buyer, it might be worth it. That's a discussion that you really need to have with your client. How long are you going to wait and hold off on this house being on the market? How long are you going to wait? How long are you going to fight this? Because if you're a seller and you sue, you can't sell the house to somebody else. If you're a seller and you sue, you still have to, you can't sell the house to somebody else while you wait for the buyer to buy the house. All right, so that's today's presentation. Let me tell you a little bit about what's coming up. The registration link is always the same. We'll have the new registration up by the end of the day today. On March 14th, will be Pi Day. I'll probably have pie with me. Homestead, what you need to know, portability, probate, and a little bit of how to apply for it. We'll be going over that. April 11th, this is one that I'm looking forward to. Don't get sued. Mistakes that agents make that could end up in court. That one should be interesting. May 9th is to be announced. We have not decided, we have not set that one up yet, but we will be looking at a guest for that. June 13th where I will have my partner, Matt Rosenthal, will actually be speaking. And that's on what realtors need to know about trusts, powers of attorney, and ladybird deeds. Let me flag that one for a minute, because as we talk about people being unavailable because they're going on trips, powers of attorney and trusts can cause issues there. If you have a good power of attorney, then you don't need to be at the closing. But if you're buying the property in the trust, power of attorney may not work for you. You're going to need to know what your client is doing and what you're dealing with there when they tell you they're going away. On July 11th, Michaela Walker with the Carrison Group is going to be speaking about social media marketing. She does excellent work with social media, with Facebook, with Instagram, with TikTok. We are a client of hers. She got me to about 4,500 followers on TikTok. I'd have more if I sat down and made more videos. And in fact, that's probably something I'll be working on this afternoon. But she does excellent work. And then we're working on filling up the rest of the year right now with, for August, September, October, November, and December. If you have suggestions for presentations or things you'd like to hear about, we'd love to hear it. Shoot me an email. I'm going to put my contact information. It's around me, but I'll also put it up on the next slide. And then, if you have questions or comments, obviously we're always happy to help. One other thing to keep in mind as we get ready, as we're doing this, we're looking at doing an in-person boot camp. It'll be a one-day, probably on a Saturday boot camp. It'll be me, a lot of me. So, sorry if you don't like how I speak, but it'll be a lot of me. But we're going to bring in hopefully a mortgage lender, an insurance person, PNC Insurance. Talk a lot about what you need to know. It's geared a little bit more towards newer agents, but what you need to know about these areas. We're going to break down what a survey shows. We're going to break down what a title commitment shows, answer contract questions, break down what a muni search shows. All these things that you need to know, because your clients are going to ask you when the title search comes in, what does all of this mean? We're going to go over it for you. And that's going to be a one-day thing that probably will not be free. There will be a small charge for it, but we'll bring in lunch. And so keep an eye out for that as we get ready to set that up as well. So there's my contact information. If you have a title order for us, you can send it to title@rosenthalmeyer.com. Goes to all of our attorneys. We're, as I said, in Avalon Park. We're in Lake Nona. And I'll open up to questions now, but thanks so much for coming.